on immigration. I am excited for all the new people that are joining us. Hello, YouTube folks. And for all the folks that have been dedicated listeners of our weekly webinar, welcome and thank you for your support. Now, we're going to wait a few minutes to have people gather. Today is March 16th, and we are going to talk H-1Bs and give you an update on the EB5 Reauthorization program. So I hope everyone has been doing well and that you all are enjoying this beautiful day that we're having, you know, with the hint of spring coming in. Again, we want to send our thoughts and prayers to all those folks that are fleeing Ukraine from the horrific bombings and blastings, and it's just, it's unthinkable what is happening. And, you know, you can never lose sight of tragedies like that because, you know, it's that, I think that poem that says something like, where everyone thinks that they weren't affected by it. And then when the person who was finally affected by it realized he was affected by it, he looked around and he said, and there was no one around to help him. So an assault on any human being is an assault on all human beings. So we, at the very least, want to make sure that, you know, we send whatever we can, positive vibes, positive thoughts, prayers to those people who are going through all these horrific acts and hope that they are safe. Now, let us get on with the weekly webinar. Like I said, it's March 16th. We are in the full throes of H-1B season. And what does that truly mean? Well, if you look at seasons past, I mean, during the Trump administration, there was a tremendous assault on the H-1Bs with RFE and denial rates at an all-time high. In fact, in 2018, it was 24% denial rate. 2019, it was 21% denial rate for H-1Bs. In 2020, it was 13%. In the first 2 quarters of 2021 had a drop to 7.1%. We are still seeing some, every once in a while, some quirky little RFEs trickling in. But typically what you want to do is focus on where do the RFEs generally, where are the links within your H-1B petition that you've got to make sure are solid. So in 2021, there were 398,269 petitions, you know, filed. And I think the highest within the past 5 years was in, you see, 2020, where it was 427,245. And that just may be even refiles for denials, because it doesn't, you know, break it down whether it's a brand new filing or a refile. And a lot of people with the denials of that year would just, you know, basically of years previously would just then refile. Petitions approved in 2021 were 407,071. And you may wonder, how come there's more petitions approved than were filed? Well, some of them would have come in the previous year. So that just shows, you know, the approval versus denial. The lowest rate was of petitions approved was, not surprisingly, 2017, 2018, and 2019. So 2019, it was 389,378 approved versus 420,000 that were filed. So in 2018, it was 330, roughly 35,000 that were approved over the 418,000 that were filed. And in 2017, roughly 73,000 were approved over the 403,000 that were filed. And remember, there's residual from the year before. So it doesn't, what was filed doesn't really reflect exactly, filed versus approval, but it does give you a clear indication that there was a surge in approvals in 2020. So administration does matter, I guess, in immigration. And as I was saying, you have to look out for what are the issues that can cause a request for evidence and then subsequently a denial. So remember, when you file, the registration season is here. So I hope those who want to avail themselves of the H-1B process are getting there, have steadily been registering their H-1B applications on the portal. That's a departure from how it was back in the day, where you'd have to file a full petition, pay legal fees, and not be sure if you were going to get selected or not. This is so much better because you only have to file the full petition once you've been selected. Selections will take place at the end of the month. When a petition is filed, it is either approved. Typically, it's not immediately denied unless, it was clearly from the face of the petition, there was no basis for requesting that classification. But usually what they will do is issue an RFE, request for evidence. And the request for evidence is basically a chance to clarify some questions that may come up that the USCIS may have had on the petition. Now, I touched on these in our session last week, but I wanted to highlight it again. I thought it was important given the time, given the H-1B period, to highlight some of those points. Number one being specialty occupation. What is a specialty occupation? A specialty occupation is one in which a bachelor's degree is a minimum requirement for entry into that position. It doesn't mean that you can't have greater than a bachelor's degree, but it just means that the job, the duties of that job would typically require someone at minimum that has a bachelor's degree. And that bachelor's degree should be related into the type of work the individual will be doing. Now, in years past, USCIS tried to narrow that to mean a specific degree. And I pulled up, the legislative discussions around when the H-1B process was enacted, and the Congress specifically rejected that it had to be a specific degree. They said it had to be a specific specialty, which is so much broader than specific degree. And so you want to make sure that you outline really clearly what the duties are. Don't use generic duties. Please don't use the DOL duties that were set up, because those occupations that are listed on the Department of Labor website that is used for the H-1B were crafted way before any of the new technology took place. So a lot of that is, first of all, it's antiquated and it's not specific enough. And then you want to relate the beneficiary's qualifications. Look at the courses they took and how they relate to the work that they will be doing. And if you're able to do that, and do that with some specificity, you shouldn't have a problem proving that it's a specialty occupation. Now, we've had cases where it's kind of, with the new hybrid master's degree programs that are trying to take multiple disciplines, and they're usually to spur innovation. They try to take multiple disciplines and kind of fuse them. And so it may be that the innovation department, the department that's issuing the degree, is like the agricultural department. But it's not really the standard agricultural degree. So how do you explain that? Well, what we did was we talked about some of the papers that they had to write, the classes, what did the people go on who were in that program go on to do? So we really delved into making sure that the USCIS understood that even though this degree came out of the agricultural department and this person was working in user interface, that didn't necessarily mean that it was unrelated. And we were able to show that it was within the specific specialty by talking a little bit about, like I said, the special projects, the papers, previous graduates, the specificities of the program. So even when it's something that seems not totally related, there are ways in which you can show that it's a related occupation. Secondly, there is a big misunderstanding between, I think it was 2019, under the Trump administration, they did talk about employer-employee relationship, and they outlined how you have to put in specific job order, the contracts, and client letters and things of that type. So when you think of employer-employer relationship, really, you have to bifurcate that issue. One is the truly standard employer-employer relationship that we obviously think of. An H-1B petition can only be filed by a U.S. employer. And that U.S. employer has to show and demonstrate that they have control over the employee's work. Now, if it's traditional employment, i.e. the person is working, I filed for an H-1B and the person is working in our office, then I don't have to demonstrate employer-employee relationship because they're at the work site. So clearly they're going to be supervised by someone within my organization because they're not at a third-party client site. Now, if I filed an H-1B and placed them at ABC Inc. doing, patent review or something, then I would have to demonstrate that that I am controlling the work. That if the employee wants to take vacation, they don't ask ABC Inc. They have to ask Challa Law. That I check in with the employee every week to see what their progress is. So I drive and direct their work. And whether it's through a project management software, whether it's through phone calls, I always tell people to make sure that they document that review process. Annual reviews also show the employee-employer relationship, as well as use of instrumentalities. If I give the employee a laptop and a cell phone to work, or equip them with, train them on some of my specialized, tools that I have some IP in, then these are all factors you can show for that traditional employer-employee relationship. So to summarize, if you are working, if the H-1B employee is working at the petitioner's work site, it's traditional employment. Don't need to show employer-employee relationship. If the employee is working at a third-party work site, somewhere other than the petitioner's work site, then you need to demonstrate employee-employer relationship. Finally, the second prong of the employer-employer relationship that gets kind of converged into that whole analysis is the idea that the USCIS, prohibited benching without pay under the Clinton administration. The big IRA bill prohibited benching. Benching meaning that you do not pay the H-1B employee when there is no work. Whatever is stated on the I-129, the employer is required to pay that no less than a monthly period. Bonuses do not count towards the salary requirement. In addition, the employer, if they offer benefits to other employees who are not H-1B employees, like US citizens and permanent residents, they have to offer the H-1B employee the same types of benefits. Again, not counted towards the salary, but in addition to the salary. If the employer would, like during COVID, employers often cite, what they're going to pay the employee on the I-129, and which is still much higher than the prevailing wage. And but during COVID, they would ask me questions like, how can I reduce the salary? And I'd always tell them they'd have to file an amended petition. Otherwise, you have to pay them whatever stated on the H-1B petition that you had filed. And then, so because that's a requirement, USCIS looks to sufficiency of work. There is anticipated work that you will have, and there is speculative. So to meet the prong of anticipated work, that's where they like to see, where are they going to be working? Do you have contracts? Do you have a memorandum of understanding or a job order for this individual? And if you do, you can show sufficiency of work. There are other ways you can do that by showing historical data that the employee has been working within this capacity. And that also helps to show, I've been working with ABC Inc. for 10 years. Yes, because most contracts or most memorandums of understanding will say that it has to be, that all the job orders and so forth have to be renewed on a 6-month basis. We've been doing it for 10 years. And it is the 6-month limitation is just set in place so that the employer, just in case there is a change in the conditions of their requirements or needs, that they are not stuck in a contract for a lengthy period of time. So just to recap, we went over specialty occupation, degree, how we need to show that not only the job through detailed job description is one that typically requires a bachelor's degree. We need to show that the beneficiary's education, relates to that degree. Relates to those job duties, and will, that gives them the background to do the necessary work. We also talked about traditional employment and employment at a third-party site, where employment at a third-party site requires demonstrating that there is an employer-employee relationship. How does the employer control the work of the employee? And then finally, we talked about sufficiency of work, making sure that you can demonstrate, because often people will ask me, I'm a new employer. Is there a specific revenue I need to have? And I say, not really, as long as you can show that there is sufficiency of work and you are demonstrating that by anticipated work, not speculative. Speculative meaning, to me, it means without any basis. Anticipated means you've got certain fact situations that support your affirmation of the work you think you will have for the H-1B employee, whereas speculative is you're just kind of hedging your bets. So that is a summary of what you need to look out for during the H-1B process. Now, to give you an update on the EB5, last week we talked about the EB5 Reauthorization program, and it's part of the omnibus bill that Congress has approved. And I looked this morning, I didn't see that President Biden signed it yet. They had expected him to sign it by the 15th, but it's going to happen, at any minute. So, we are expecting that certain provisions of that will take place immediately, which is the increase in the fees. We were hoping that we would have some time for that to take place, but it will be effective on enactment, and enactment will be when the president signs the bill. There is a portion of, even though it is an increase, one thing that seems to be very beneficial, and we're going to tease this out, in the next coming weeks is the ability to file for an adjustment of status concurrently, where you couldn't do that before. You would have to wait for the I-526 to be approved before you could file the adjustment. Now you can seemingly file the adjustment concurrently. And at least from the way I have read the legislation, it states that the ability to file for a concurrent adjustment will take place immediately upon enactment. And you can either file concurrently for any new applications that are going forward, or you can file an adjustment to an existing application, which leads me to believe that even those that are pending would be able to benefit from this. There are certain things from a strategic perspective that you need to think about based on your current status. H1s, this is great for them because they would be able to benefit, especially those that have just started their permanent residence process, and you don't seem to see the light of day in terms of any reform on the visa backlogs. This is a great opportunity. And for H-1Bs, because they're dual intent, travel and other things are not impacted by filing. If you are on any other classification other than an H or L, then the one thing you do need to look out for is you cannot travel until the advance parole is issued. And we've talked about how, the advance parole is taking an incredibly long time because of backlogs. So we'll see how that plays out. And we'll keep you posted with any new updates next week. Before we go into our Q&A session, which I know that's what the most of you are interested in, I wanted to at least put up our social media slides. So to make it easy for you, I know my team is going to put up the links on the chat, but if you haven't joined our forum on Telegram, this is a special invitation to invite you to an amazing group of people who may be in the same situation as you are. So it is not only community support, but community information. And it's an amazing group to be around, and probably one of the few where no one's charging you for information that we're posting on there. All you got to do, if you are on your computer, is stick up your phone. You'll get a link. You can join with the link. And if you've already joined, you can take the link and share it with some of your friends. And so we can grow the community even more. If you have not registered for our weekly webinars and you just by chance happen to be on YouTube when you saw this coming up, or, please register for our webinars so you can get the latest information on immigration to help you with your immigration journey. Again, all you have to do is stick the phone up, wait for the, link, and then boom, you can join. And like I said, if you are on your cell phone, then I'm sure Lainey will put the links up, in the chat. And then finally, join us on our YouTube channel, where we have a lot of information. In fact, questions that we see coming in every week. A lot of that information is contained within the great videos we have up, and even in the videos that we will be posting. So unless you subscribe, you won't know when we're posting up new information. And you don't want to miss out on the new information, right? So make sure you join our channel. Again, you put this up, you get a little link, and you can subscribe. We look forward to listening to your feedback. We hope that if you like it, that you will not only subscribe, but you will share it with your friends. So thank you again. And I will now ask our moderator, Mr. Shekhar Challa, to join us so he can Q&A. And Shekhar, today I'm being interviewed by the some Richmond magazine after this webinar. So I've got to make sure I close out at a hard one.
Sure. Congratulations on the interview. I'm sure you'll do well. Good afternoon, everybody. Hope you are doing well. So let's jump in and see what's happening. Just see, I always go by this timestamp. So let me look at the first question from the Q&A. Can you interfile from EB3 to EB2 if the date of filing is current in EB2 but not final action date?
I believe you can, but let me check and get back to you. So email us at info@challalaw.com, and I just want to confirm that it is the final act. I mean, that you can do it on the dates of filing. I believe you can, but I just want to, so I may have that before we finish today. So anyway, next question.
All right. Ritesh Kumar is asking, sorry to bring this question. I already got an answer from your firm on email. This is quite common, hence like to bring this for everyone. I'm updating my spouse name change on our Indian passport and will process H4 extension subsequently. How to update her name change on pending I-485? Did downgrade in October 2020. Can we fill form I-90 or just sending a letter as an interfiling will work?
Right. In the past, we have submitted a letter and all the supporting documents showing the name change. The reason why, I think the question was, should I do it now while it's pending, or should I do it when it's approved? I think it makes it easier if you do it while it's pending, because that way at least your card, your permanent resident card, will reflect the new name. And so I would think that would be, a better way to do that than wait for the approval notice and then have to take care of all of that at one time.
All right. Next question. Is there any hope on EB3 to reach December 2013 this year, or any new change in legislation which can benefit?
Wow, that's a pretty loaded question. So, I mean, I wish I had the insight for that. I really do. Unfortunately, we cannot predict. As I said before, there's a number of factors that may impact the employment-based petitions. So we just have to wait and see. As far as any new legislation, I wouldn't hold my breath anytime soon. It would be nice if they could get it together, but and I say that, and who knows? Right now we are, most businesses are really having, and all the data reflects it, a shortage of workforce in all areas. And unfortunately, unless you have, mechanisms to bring people in, you can't grow the economy, businesses can't grow. So I hope that they will see beyond their political views and see the economic benefit of actually trying to do something to overhaul the immigration process. But like I said, right now, I'm not so confident.
Okay, next question. File downgrade plus I-485 in 2020, PD 2014, received EAD AP. Now my date is current in EB2, date of filing, and planning to file another I-485 next month. What happened to my current EAD AP? Can I use the current AP to re-enter the US, which was received from AOS filed in 2020?
Right. Well, you said you're planning to file another I-485, but you haven't. So yes, if you read the regulations clearly, it states you cannot adjust. That means you cannot become a non-immigrant to a permanent resident on more than one adjustment. It doesn't say you can't file more than one adjustment. It just says you can't adjust. So, as long as that I-140 and 485 pursuant to your 2020 filing, I would imagine it's 2020 filing is valid, then yes, you can travel and return on that.
All right, this next question is from YouTube. V. Lakshmi is asking, two currently Texas adjudicated, V. Lakshmi 2, I guess. Currently, Texas educated only 3,000 in first quarter, whereas NBC did 33,000. Anything we can inform or from your side?
Yeah, I mean, Texas is, has always been incredibly slow. I mean, that's since I've been practicing. I don't ever remember where anyone said, "Oh, wow, I'm glad my petition's at the Texas Service Center." So I don't know the reason why they're like that, and I don't know if there's anything that can be done, clearly with the money that Congress has infused for streamlining processes and eliminating backlogs. They should look at some of the linchpins or some of the sites that are having slower processing and try to see how things can be improved. But, we'll have to see.
All right. This next question also from YouTube. I think so, because the person put the question again right now. I have EB2 I140 filed with new perm in October 2020, is pending for 17 months. Now that perm is expired, can I file EB2 140 without pending EB3 140 approval, or I need to have EB3 approved first?
So you filed the I-140
EB3
with the
I-140
perm before it expired?
Says I filed EB3 I-140 filed with new perm in October 2020, pending for 17 months. So now that is perm is expired, can I file the EB2 I-140 without pending EB3 I-140 approval, or I need to have EB3 approved first?
Yes, I believe you need to have the EB3 approved, and you should be able to do premium processing by now. I know we had some folks that said 9 months out that they 9 months after filing the I-140, I-45 concurrent that they weren't able to. We were successful in several of our upgrades, but by now you should be able to upgrade and get it approved.
All right. This question from YouTube, V. Lakshmi 2. My daughter is in medical school as international student. Her I-485 pending and age locked. Can we expedite her I-485 as GC holder versus international student? Difference lot on grants and financial aid.
Right. Well, for all practical purposes, she is an adjustee. And so for most, and this is a good question. So for most, and it depends on the state, but for most states, if you meet the requirements of domicile in the state of Virginia, for example, you have to have the present intent to remain in Virginia, and I'm trying to think of the word, I'm going brain dead, present intent to remain in Virginia permanently. So you don't have to remain here permanently, but you have to have the ability to remain here permanently. When you're on an F1, you can't have the intent to remain here permanently because you've got to return to your home country because that's a representation you made. As an adjustee, you can intend to remain here permanently. So in Virginia, if you show your receipt notice and, so you've met the physical presence requirement and you have met the intent requirement of the domicile guidelines, then you can be eligible for in-state tuition as an adjustee.
All right. Lakshmi too is asking another question from YouTube. My attorney received I-131 10 days back, but I-512 advanced parole document was not received yet. Is it normal?
Usually they're issued together. You're not the first that I've heard that they're receiving them separately. I think a lot of folks have received them separately this time. So, but we have seen that within, a few weeks, you will get, your advanced parole as well.
All right.
So it's not unusual, in other words.
This next question is from YouTube. It's from Kellogg's fan. Kellogg Business School or the Kellogg's cereal? Just kidding. I'm sure it's a Kellogg's Business School, I want to think. Question, can I adjust status if my class of admission was C1 in transit, not crewman, just pure C1 going to a third country and never left the States? Thank you.
So you came here as a transit and never left. So you overstayed. And your question is, how can you fix that? That's a complicated question because there's special rules that apply to transits versus other overstays. So email us at info@challalaw.com, especially because it's such a specific question. And like I said, it's such a detailed answer. I think it would be better served in an email format rather than through discussion here. Because I have to go through some of the nuances.
Next question from an AA. Are there any risk of interfiling from EB3 to EB2? My EB2 is current in today's bulletin. Any suggestion?
No. There's no interfiling poses no risks in and of itself. No. So I would go ahead and do it.
All right. This next question from YouTube, Shivam Garaju. If I left US after I-140 approval and 6 years of staying US, but want to enter again on H-1B via a different employer, should lottery application mandatory?
So the rule is you are not subject to the H-1B cap if you have had an H-1B within the past 6 years. If it's been beyond 6 years, then you would be cap subject again.
What will happen if I filed a lottery, even though it is not required?
Nothing. I mean, if you've been outside the US for more than 1 year, even if you're within that 6-year window, you have the option of doing either. So there's no there's no penalty if you do it that way.
All right. Here is the sweet seller from YouTube. Does NBC really process the cases, or will all the cases be sent to field officers for processing?
No, they do some preliminary review at those centers, and then they send it down to the field office.
All right. This next question from Karthik Rajashekaran. I have downgraded to EB3 with 485 and moved to a new employer with 485J. With EB2 filing date current for my PD, I want to refile EB2 using previous company I140. Is it possible?
Yeah, if you've got the present intent to work for that company in the future, yes.
All right. I think that's about all for now.
Okay, very good.
So,
Well, I want to thank my team for all their hard work. Thank Shaker for his great moderating. And tomorrow we're doing, I think it's tomorrow, or Lainey will put on the chat when we're going to do it. We're doing a special webinar, H-1B compliance for employers. So if you've got a new employer, or if this is an employer that's going to be filing your H-1B, this is probably a webinar they don't want to miss, because it kind of walks them through what they need to do to make sure that they're compliant during this process.
So just a follow up from Karthik, he's asking, should I go back to previous company after refile?
You have to have the present intent to go back to that company after your permanent residence is approved.
All right, I'll take this last question. And like I guess we said, Lakshmi has an interview to prepare. So I'll take this last question. Maybe there's another one on the YouTube, I don't know. But this one, thanks for reply. Once interfile to EB2, is it that now I am in EB2 queue, or is there some gray area, like you are on either side? As I heard, there's no confirmation from USCIS for interfile.
Yeah, there's no receipt notice for interfiling, and you're not in a gray area. You're in the best of both worlds, I would think of it. So whichever one is able to, whichever one becomes current first, that is the I-140 that you're leveraging for your adjustment. So you're getting your bang for your buck. Two birds, one stone.
Yeah, one leg in hot water, one in cold water. Just kidding. Just want to lighten up on a Wednesday afternoon. Just want to remind you the most funnest part of cricket is starting on March 26th, the IPL 2022 for the next 7 weeks. Let's go. Sunrisers, Hyderabad. Even though David Warner is playing for Delhi this year.
All right. Well, I'm sure we'll hear a lot about the IPL from you while it's going on. So we look forward to that.
I'm sorry, but that's, I'm very passionate about it because I was there on the inaugural year. I watched the match between that time it was Deccan Chargers and it was Chennai Super Kings. I was there live in Hyderabad. So thank you.
Well, that's fine. Thank you. You all have a great week. We'll see you next week for our next webinar on who knows what the latest topics will be, but we will, if you've registered, then you'll know what our topic will be for next week. You'll get that information. Thank you all again. Have a great week, and we look forward to seeing you next week.
I just want to remind about that registration for tomorrow's webinar is on the chat. If you like to,
If you want to give that to your employers, especially if you're filing a new H-1B, it's kind of nice because they feel more comfortable with the process after learning about what the regulatory requirements are. So share with your folks and look forward to seeing you